Attorney General Jeff Sessions today insisted his recusal from the Russian investigation was all about following the law.
I recuse myself not because of any asserted wrongdoing or any belief that I may have been involved in any wrongdoing in the campaign, but because a Department of Justice regulation, 28 CFR 45.2, I felt required it. That regulation states in effect that department employees should not participate in investigations of a campaign if they served as a campaign advisor.
That sounds very straightforward. And joining us to assess the Sessions hearing, the leftist special counsel and much more, George Washington University law professor Jonathan Turley. Professor, great to have you with us. Is the Attorney General right about the reason for his recusal?
I think he is. And he made the point that he effectively or constructively recused himself virtually from the beginning, because he was fairly certain that he would have to recuse himself. And that was one of the more interesting things about the hearing, because I agree with him that that regulation does militate heavily in favor of recusal. But what was interesting is that he took those prospective steps. He said that as soon as he became Attorney General, he was already imposing on himself essentially a recusal, and that he virtually saw nothing from the Russian investigation.
And much of today's hearing, as you know, well, first of all, it was the result of the insinuations, the innuendo of James Comey as he was testifying before the same committee that motivated the Attorney General to ask to testify in open hearing before this committee. Let's turn, if we may, and listen to Senator Cotton on these leaks, including those by the former fired FBI Director James Comey.
Are these leaks serious threats to our national security, and is the Department of Justice taking them with the appropriate degree of seriousness in investigating and ultimately going to prosecute them to the fullest extent of the law?
Some of these leaks, as you well know, are extraordinarily damaging to the United States security. And we have got to restore a regular order principle. We cannot have persons in our intelligence agencies, our investigative agencies, or in Congress leaking sensitive matters on staff. So this is, I'm afraid, will result in, is already resulting in investigations, and I'm fear that some people may find that they wish they hadn't leaked.
I don't know if his fears, Professor, extend to James Comey. I think their relationship is a little somewhat tested at this point. Does James Comey, do you believe he's in legal jeopardy as a result of having leaked what is obviously the work product while he was the director of the FBI?
Well, I disagree with a number of legal analysts who, first of all, said this isn't a leak because it's not classified. Which is really quite unsound and unsupportable. You can have a leak that's not classified. It happens all the time. A leak is an unauthorized disclosure of information, and that's what this is. More importantly, the FBI has always adopted, including under Director Comey, a very broad definition of what constitutes FBI information. This seems to me squarely within that definition. He prepared this on an FBI computer. It was about an ongoing FBI investigation. He put it into the file. He told his staff about it out of his concern and its impact on the investigation. It really walks and talks like FBI information. Now,
you think he should be prosecuted?
Well, I think it's unlikely that he could be prosecuted. We have had senators who say they think this is government property, and there is a statute for that. But it also allows the FBI to go to court. You know, most FBI employees sign an agreement that says that they can be brought into court civilly or criminally for unauthorized disclosures of FBI information. They could seek to enjoin him. They could seek even to search his files.
And how much jeopardy, if any, did he place his friend, Daniel Richman, a law professor at Columbia University, who actually leaked then to the New York Times? How much jeopardy did he put him in?
Well, that's what's sort of fascinating about the spin on this. Some experts have said you know, Comey really didn't remove anything because his friend just read from one of the memos. But if you look at it closely, it sounds like he gave that professor the memos and he read from them. So he did disclose it to a third party. As for the professor, I think that he's going to be a collateral player either way. Now, the White House is suggesting that there might be other leaks connected to Director Comey. That would be a truly startling development. It would put him in peril.
And your judgment on Attorney General Sessions' assertion of appropriateness as the Attorney General to refuse to answer questions about conversations between the President and the Attorney General.
Well, I heard it a bit differently than how it's being treated. It seemed to me that he was referring to executive privilege. I think the Democrats were right procedurally. The White House counsel should have sent a letter that said we are invoking executive privilege over any communications within the Oval Office and the Attorney General. If they said that, they would have been squarely within the claim of executive privilege made by prior administrations, including the Obama administration. But General Sessions was right constitutionally. These questions did fall pretty squarely within what other administrations have said is covered by the privilege.